Well, hello all. Welcome to IP and Me, Demystifying Intellectual Property. My name is Mike Hazen. I'm a member of the Barristers section, and I'm really pleased to be presenting this topic. When Ariel asked for suggestions on possible topics, I jumped right at the opportunity to have my friend and partner, Pete Tormey, present his lecture on intellectual property. Pete has been a guest lecturer for my business law classes at Diablo Valley College. He was a professor at John.
Oh, that sounds good.
He was a professor at John F. Kennedy University. He's the founding and managing partner of Antero, Tormey, and Petrin PC, a boutique IP and business law firm located in Pleasant Hill. He holds a bachelor's in electrical engineering from San Francisco State University. He holds an MBA from St. Mary's, and he has his JD from John F. Kennedy University. So without further ado, I give you my friend and partner, Pete Tormey. Take it away, Pete.
Great, thanks, Mike. I'm assuming everyone can hear me okay. We tested everything, so I'll get right into it. The overall intellectual property is a broad category, and so the purpose today is to kind of simplify it into some basic common themes that you can use in your practice and throw in a little bit of law, but mostly practice tips, things I've found out, I've learned along the way. And it's kind of the things I wish everybody knew that would just make everyone's life a lot happier. So at the end, all the slides will be given to you in a handout. You can kind of refer to them later on. So the first thing to know about intellectual property is that it doesn't protect ideas. It protects the manifestation of that idea. And so, you know, if you have an idea, a boy meets a girl, but their families hate each other, so they fall in love and kill themselves, that's just an idea. But once you put the name to it, Romeo meets Juliet, right? Juliet loves Romeo. You have a family, you have a place, you have a setting, you have words. Now you've manifested that idea into something real, the story of Romeo and Juliet, which is now copyrightable and may be protected by other forms of intellectual property, which we'll talk about. So you'll get clients to say, I have this idea, I want to protect it. Well, they have to have it advanced enough so that it can be manifested in some way, right? You have to be able to write it down, sing it, or something that we can say, okay, it's in a tangible form, we can do something with it. So we'll go through all those topics, the different ways of covering it as we go along. But I have the first kind of overlying theme I use is in business. And remember, intellectual property is almost always a business deal. So there are people trying to make money fundamentally, or they invented something they want to sell. So it's in the realm of business. And the best way to think about intellectual property is as what we call a sustainable competitive advantage, something you give that nobody else does. It gives you an advantage over the long haul. So it may be a limited monopoly, like a patent. It may be something creative and clever, like a trademark, or something along those lines. But what we're looking for is it doesn't make you faster, better, or cheaper than the competition. And if it does, it's probably worth protecting, because if the competitor gets it, you're not going to be happy. So that's the world we look at. The main theme we go into is sustainable competitive advantage, something you can keep. There's other forms of SEA, sustainable competitive advantages. That your business, if you have business clients, they'll know about it. For instance, money. Having a lot of money is a good advantage, right? Having a good network, a good Rolodex full of people that can help your business, that's nice too. But we're just going to limit ourselves to the four main categories of intellectual property. These are trade secret, copyright, trademark, and patents. And a trade secret, you probably heard a lot about it. I'll give you more details later in the presentation, but it's your secret sauce. What you do, what you know that no one else knows is going to make you a lot of money. Your copyright, this you're probably very familiar with. This is for artists, pitchers, songwriters, things like that. Once they set it into tangible form, you can copyright it. Trademarks start to get a little more esoteric, because what a trademark does is it identifies the company. When you see the Nike swoosh on a pair of shoes, you know it comes from Nike and not some counterfeiter. That's the idea behind trademark. It's actually a basic form of consumer protection. And then there's patents, and then that gets a little more involved, because you have to have some invention of something, usually tangible. Software can fit into that, that is new and not obvious, and is some kind of radical improvement over what's going on. And we'll talk about that in detail. So for this presentation, we're just going to look at these four topics, and that'll be enough. Your head hopefully will be full at the end of the hour, and we'll go from there. But we're lawyers, so we have to start here with the legal document, and that is the non-disclosure agreement. And you're probably all familiar with them, and a lot of people have said, "I'll get a signed non-disclosure agreement." They're great. There's a couple problems with them. Often they just aren't very good. Someone will say, I have a non-disclosure agreement, and the description of what's not disclosed is my invention for a new, kitty litter box or something, right? Nothing that a court can sink their teeth into and say this is actually protected. So non-disclosure agreements, it's nice to have them, but they have to write them with enough detail so you know that it's enforceable. You can actually enforce it. One way to give your clients a heart attack is to hand them like an 8-page non-disclosure agreement. They'll never read it and they'll never sign it. So you're probably going to have to keep them short and sweet and to the point. They can be difficult to enforce because they tend to be vague. People just download them off the internet and use them. They work to some degree if they're filled out properly. I think the best legal advice when your client comes in is only disclose what is absolutely necessary. That's the best protection. Don't tell them what they don't need to know. Tell them what they need to know and nothing more. And finally, with non-disclosures, investors generally won't sign them. There's these people that invest in products, venture capitalists, angel investors, and things like that. They invest in a lot of companies. And if you hand them a non-disclosure agreement, they're not going to sign it because they're going to see another company maybe very similar to yours, and they don't want to get liable. They see a lot of companies. If you're a venture firm specializing in artificial intelligence, you're not going to sign anything that's going to make you liable. It isn't worth it. So what they're going to tell you to do is protect your intellectual property first. File for a patent or file for a trademark or a copyright or whatever it is. And then we'll talk to you, because then we don't have to worry that we're going to get sued. So non-disclosure agreements, they have a place. They aren't as strong as you think. Usually they aren't done well. And often by the time you even find out about it, they walk in and they downloaded one really bad non-disclosure agreements. And that's kind of your starting point of your first meeting. So just a heads up on those. And then we'll get into trade secrets. Trade secrets are a really beautiful form of intellectual property if you can get your clients to follow the rules. And the rule sounds very simple, but it's this: keep it a secret. Don't tell anyone who doesn't have a need to know. And if you think about the recipe for Coca-Cola or Kentucky Fried Chicken, I think Famous Amos cookies, there's all kinds of things that the recipes are a trade secret. Day trading algorithms, they know how to trade stocks to make money, and they don't tell anybody about it because it's their trade secret. It's their secret sauce that they don't want the public to know. They can be a lot of things. They can be how to find customers. If you're a law firm and you have a unique way to find new customers, keep it a secret, because if you tell all the other lawyers, they're going to do it, right? So you get the idea. Sales techniques, financing options, any pre-patent information before you apply for a patent, you want that a secret. Marketing, manufacturing, software. We often have software clients and we tell them, if you can keep it hidden behind that software firewall, behind the network so nobody sees it, keep it as a trade secret. You're probably much better off. A quick test for you is if the product can be reverse engineered, it's probably not a good trade secret candidate. But if you can't reverse engineer it, if I give you a thing that's made, you can probably reverse engineer what it is, but you'll have a hard time reverse engineering the process of making it, of putting it together. It may be glued, may be done at a certain temperature. There may be steps you can keep a secret to making that product that can't be reverse or easily reverse engineered. Therefore, it's a candidate for a trade secret. Why are trade secrets important? Because they're protected by law. There's two laws here, statutes here I'll put up for you to review. Later on, it'll be in the handout, so you don't have to write about it. But there is a Uniform Trade Secrets Act that all the states, it's kind of like the Uniform Commercial Code. Most of the states have adopted some form of it. And there's the site to it if you need it. But what trade secrets are protectable in the sense that you can keep an employee from walking off with a trade secret, and you can keep their new employer from using that trade secret. And now we have recently, in the last, well, I guess maybe it was the late 90s, the Defend Trade Secrets Act, which is a federal cause of action that covers similar things. So the state and federal go hand in hand on this. Let's take a look at what they'll do. you probably have written, if you've ever done an employment agreement for a company, something in there about trade secrets. And it will say, you cannot bring a trade secret into this company. And when you leave, you can't take any trade secrets with you. And here's why, because if you scalp an employee from a competitor and he brings a trade secret in, that competitor can bring a cause of action against you and have you stop using that trade secret and create liability for you. So you don't want to do that. I believe, as I mentioned earlier, just don't tell your secrets to anyone. Treat it like it's a real secret. Supposedly, the recipe for Coca-Cola is known by only like 5 or 6 people. That's urban legend. I don't know how many people really know it, but we know for a fact that it's not out in the public and they guard it. And they don't tell it to anyone unless they need to know. Don't even tell investors. People think they're looking for money. And they got an investor who's interested and they're dying to tell them what we know that nobody else knows. But I had an attorney brag to me. I'll get that investor on the stand and I'll say, did you know about this secret? And if they answer yes, I'm going to break that trade secret protection because the investors almost never have a need to know. They're not going to use it. The people who invest in Coke don't need to know the recipe. The people who make Coke do, but not the investors. So even investors don't need to know the secret. Keep it under lock and key. That's your defense. The recipe for Coke is hidden, locked away somewhere in a cabinet by a trusted person, and that's it. You can do that with anything. If it's behind a firewall and it's a piece of software, the code is only managed by a couple of people. It's not disseminated to the whole company. It's a secret, and you treat it like a secret, and you get the benefits of trade secret protection. And trade secret protection is free. Basically, the company doesn't have to do anything. You don't have to pay a patent attorney to lock it up or register to get pre-approval or any of that stuff. It's free. Keep it treated like a trade secret, and it's a secret. Let your employees know. So here's some practice tips. If you get around trade secrets, have it in your employment agreements and your independent contractor agreements that they don't bring any trade secrets in and they don't take any out. Review trade secrets for new hires to keep them from bringing anything in so they know. And in your exit interview, when you leave the firm, you should have an exit interview with your employee that says, hey, just a reminder that the way we were doing ABC is a trade secret, and you agreed you would not be sharing that with anybody, and we want to remind you that you aren't going to do that. I know that exit interviews, in a friendly exit, that's easy to do. Not all exits are friendly, and you're going to need to follow up with the letter, but put that in the letter. So make sure they know so that you don't end up in a situation of having to sue over it later on. Now we'll move on to copyrights. A copyright is basically another very affordable form of intellectual property protection. It belongs to the author as soon as they set it into some tangible form. If I create a song, if I sing a song to you, it's not in tangible form. But if I record that song, it's in tangible form, and I'm entitled to the copyright on that recording. If I write a document, I'm entitled to the copyright on it. If I take a photograph, I'm entitled to the copyright on it. It is automatic. It's easy to protect, but there's an interesting rule when you protect it. If you register that copyright office with the copyright, if you register your production with the copyright office, you get some real benefits. First of all, in order to sue for copyright, you have to be registered with the Copyright Office. But if you register within 3 months of its first public use, you get statutory damages, which is great for us as lawyers. And let me give you an example of how that works. Let's say you have a beautiful picture of Maui and you put it up on your webpage, and about a year later, someone knocks it off and uses an ad. You can sue them. You can say, that's my copyrighted picture. You're not authorized to use it. Stop it. And you can get an injunction to make them stop. If they made a profit with it, you can disgorge those profits, which is great. But if you registered your copyright that photograph before you made it public, you can get statutory damages of up to $10,000 per infringement. And now there's some money. There's some money at the end of the case, right? That'll make, lost damages on a photograph probably isn't a lot of money. Your legal fees are going to quickly eat that up. Statutory damages is a way you can say, all right, you registered it in advance, and now we can get statutory damages if you can convince a judge to award you that. And now you have a real lawsuit you can go with and actually provide some protection for your clients. The trick is, and what most people don't know, is you have to register that document or that article with the Copyright Office in advance before you make it public, or within 3 months of making it public. Very easy to do. Copyright.gov, I think it's $65 to upload the document and you register with the Copyright Office. Fundamentally, it's the Library of Congress. That's the person, the entity you're filing it with. Keep a record of it because it's not a searchable database, and you'll want to make sure that you have, the copyright number that you're going to need to enforce it. So if you have a client that is involved in the world of creativity, you want to get familiar with this copyright process of acquiring copyrights at the right time. Second thing is have some policies regarding copyrights. Make sure that your employees know when to claim the copyright. If you have employment agreements, make sure that they transfer the copyrights to you completely, because copyrights, especially for contract employees, have to be in writing to transfer them. There may be an implied license if they're working for you, and there may be work for hire clause, but even work for hire conditions. But even with those, we always prefer a signed writing transferring all of the copyright to the employer, to your client. I'm kind of speaking from the employer client perspective right now. What happens is copyrights, like all property rights, are really a bundle of rights. So it's not a single one. So you can have a creative person who's doing something, creating some piece of art that you're going to use in your business, but the license doesn't include every single right for that copyright. So you want to have a writing that says all of the rights go to you. Except for maybe the right of attribution, which is the right of the author to say, I wrote it. But generally, you want them all to go with you because later on you might want them. So the only way you're going to get that transfer is in a writing. You're not going to get it in a work for hire. So have a policy to protect other works. We'll talk about that in a little bit. A lot of companies use open source software. Especially now on the internet, it's open source, which means they're using software that's copyrighted by other people and they have a license to do it. Know the limits of those licenses, those licensing agreements, and train your employees. Let's take a look at a little more. Don't grab images off the web. One of the very first cases I had as an attorney, a lady walked in my office and she had a cease and desist letter and a $5,000 settlement demand because she grabbed a picture off the web and used it on her company webpage. Unfortunately, the cost of defending against it was going to be more than the license fee. So we very quickly turned it into let's negotiate and see if we can just get a reduced fee, because the cost of the lawyer is going to be prohibitive. Of course, the person enforcing that right, they knew that. That's why they picked the $5,000 price tag, right? So best way to protect your clients, don't grab images off the web. There's all kinds of databases of images now, and they're cheap. They're $1 or $2 each, and you can just get a license to use them. So just buy the images and make sure your clients know that. Have your employment agreement transfer all of their copyright, all of their intellectual property completely to you as part of the agreement. Often you'll have creative people that will object to that, and you're just going to have to deal with that depending on the nature of the industry. I know in the software world, people come in with software they've already written and they use it on projects because it's their own software. So they're going to be hesitant to give you exclusive rights to it, but you're just going to have to deal with it. That's the nature of the industry. If you have a creative person that does advertising copy or advertising material, they often have standard tricks and things they're going to use from their portfolio to benefit you. And there'll be some blowback on that licensing agreement, but you can just clarify that as part of the process of bringing them on board. But generally, employees, you want to get all their copyrights assigned to the company if they can. Mark your copyrighted material because it puts the world on notice that you're claiming a copyright on this. And notice helps a lot, so they can't defend. I've never heard of it when you have a copyright on everything you've done. I have a good time with copyrights because this is a paragraph I pulled from Google's terms of service. If you've ever used Gmail, and most people have a free Gmail account, and I pulled this a couple of years ago, I don't know if it's still current, but when you sign up for your Gmail account, you agree to this sentence. By submitting, posting, or displaying the content, you give Google a perpetual, irrevocable, worldwide, royalty-free, exclusive license, reproduce, adapt, publish, publicly form, any content which you use through our services. This is a pretty broad license agreement. And whenever I get like a patent invention disclosure sent from a Gmail account, I often write back, do you have another email account? Because you send me your patent and Google's claiming a right to distribute that information around the world. Just so you know. And but anyhow, I think it's funny, well written. I don't know if it's enforceable, if Google's ever tried to enforce it. If you know, send me an email. I'd love to see the case. Trademarks. So we've covered trade secrets and we've covered copyrights. Those are the easiest to understand and easiest to protect. With trade secret, keep it a secret. With copyright, register it as soon as you possibly can with copyright.gov. It'll give you some advantages when it comes to enforcement. Now we're moving on to trademarks. And a trademark, as I mentioned earlier, is some identifier that tells the public who is the source of this product. And the story is, I don't know if it's true, but it's a great story. And it goes like this. Hold on just a second. Some years ago in ancient England, there was a sword maker who made great swords. And he stamped all the swords with his initials, so everybody knew he made great swords. Somebody who made poor swords realized that if they put the other guy's initials on their swords, they could sell them for a lot more money, and they did. And what happened in battle is the poor swords, the low quality ones, failed. Well, that upset the king because he had a bunch of troops that were dying in the field because they had really crappy swords. And the reason is that somebody mislabeled them, put someone else's name on them. And I think this was probably in the 11 or 1200s. So England has recognizes the earliest trademark protection laws, and they date back to the 1200s, simply because everyone has an interest in knowing who made this product. So it's a consumer protection idea. If you buy a handbag, it says Gucci on it, you want to know it's really a Gucci handbag and not a knockoff. You buy a watch that has Rolex on it, you want to make sure it's a Rolex watch and not a knockoff. So all of society has an interest in this. The trademark is any indication of where the source of the product is, where it came from. If you have a swoosh on your sneaker, you know it's Nike, it's a Nike swoosh. If you have, in fact, one of the trademarks in the last couple of years was a color, a women's shoes, a color on the bottom, a red color on the bottom of the shoes, and they trademarked that as saying, this is an indicator to the buying public that this shoe is made by our firm. And you can all think of a million, I think I read a statistic once that the average person sees 12,000 trademarks a day. So every car has the name of the car on it, has the name of the dealership on it. All those things that identify the source of a product are trademarkable. I believe, and the reason I'm going to spend a little bit of time on trademark is that for business clients, trademarks are the most valuable form of intellectual property. They're not the most expensive, patents are generally, but trademarks are valuable because they live forever, for as long as the company lives. Coca-Cola as a trademark has been around a long time. The Nike shoes, whatever they patented when they first came out, the patents long since expired. They only last 20 years. But the Nike name, very valuable, and it'll last for another 100 years as long as the company stays afloat. So when you register a trademark, it provides certain benefits. It keeps others, first of all, it tells people you're claiming this as your trademark, so they're on notice. It protects against dilution or misuse by others. If everybody used the trademark Ford on all of their products, the Ford brand would go to zero, would be very little value. And that's called dilution. And so when everybody is using a similar trademark, that dilutes it. It takes the brand value out of it. But like the Nike swoosh or the Coca-Cola name, it embodies the total value of your company to the public. When they look at it and they say, oh, Nike, good quality shoes, I'll pay the money. They look at another brand that doesn't have that and they're thinking low quality shoes, I won't pay the money. So brand equity is what we call it. And trademarks encapsulate that brand equity for your client. So registering the trademark gives you the rights to enforce it easier than there's a common law trademark right and a registered trademark, which goes through the trademark office. If you register, it's easier to enforce. For instance, you can go to customs and immigration at the border. You get a boatload full of fake Gucci purses come in. Gucci can say, they're not ours, but they have our trademark on them. And customs and immigration will either deny them entry or confiscate them. And you can actually have trademark hearings in front of the customs and border officials to decide if the trademark's valid and which one, whether it's infringing and things like that. So you move it out of the federal courts into an administrative agency, which may go a lot faster for you. Registration protects your internet domain. If you have a Coca-Cola.com, I haven't checked to see if that's a real domain, but I suspect it is. And Coca-Cola can protect that because they have the registered trademark on it. So trademarks are, I believe, exceptionally powerful tools for keeping that brand equity in your company. Couple things. There are state and federal trademark laws. California has a trademark registry. Most people don't even know about it. And then there's federal ones. Trademark law predates the Constitution. The colonies had trademarks. The King of England had a trademark back in 1200. So what you need to know for your practice is that the federal trademark registration involves interstate commerce. That's the restriction on the Constitution. But if you have a small business, like our office is in Pleasant Hill, and you're unlikely to leave Pleasant Hill, then the place you want to register that trademark is going to be with the state. If you're unlikely to leave California, so if you're, a hair salon or something that isn't likely to extend your reach out into the other states, you want to register your trademark with California. The federal law is the Lanham Act. And I put the site there for it. You don't want to read the whole thing, but you'll often just see it abbreviated as the Lanham Act. That's what we call it. And when you register your trademark, there are two possible things that can, well, you may get rejected. I'll go over the trademark process in a minute, but there's two registers. One of them is the principal, and that's the trademark rights. You're familiar with it. We own it. You can't use it. We're registered on the principal register, but there's also a supplemental register. And what that means is that if you have a trademark that the trademark office thinks is merely descriptive, in other words, it's really not a strong trademark, and I'll talk about those in a minute, you can list it on a supplemental register, basically telling the world, putting the world on notice that I'm using this, I'm claiming this as my trademark, and kind of relying on common law trademark rights instead of statutory trademark rights. So there's two kind of areas of law, the state and local, and then the statutory, and then there's common law rights in trademark enforcement. This is the process. I won't bore you with it, but what you do need to know as an attorney is just because you file for a trademark doesn't mean you get it. The trademark office will examine it and they may reject it. They may reject it for good reasons. They may reject it for bad reasons. Once you're done arguing with the trademark examiner, the trademark will be published for opposition. And this gives the world an opportunity to object to you getting the trademark. If nobody objects, you get a registration. If somebody objects, you get a mini trial, basically, that's held in front of the trademark office. They'll have a 3-judge panel. They won't be judges, they'll be attorneys with a primary investigator looking into it, and then 2 people kind of concurring with them. And they'll make a decision on whether or not you get the trademark. So this is the process for trademark. Surprisingly, very similar to the process for patents. In fact, the Patent and Trademark Office are the same, 2 branches of the same government agency, and it works kind of the same way. You apply, they say, in the trademark process, they usually say yes right away. In the patent process, they usually say no. So that's one of the big differences between them. But they go through this process where you argue with the office for a while. And then in the trademark case, the world gets an opportunity to object, because you might not know, you might be using a trademark and then find out somebody down the road is claiming your trademark, and you need to speak up to protect your rights. So that's published. And there's search companies that will keep an eye on this for you and give you notice if anybody tries to publish a trademark that might affect your business. So one of the things we do, we have a lot of business clients, is we recommend different ways to think about how they should build their trademark. And the first thing is to remember or to know is that trademarks are industry specific. So if you look at Pandora music versus Pandora jewelry, they're 2 totally different industries. And the trademark is exactly the same, it's Pandora. And the reason is that nobody looking at Pandora or listening to Pandora music would confuse it with the jewelry company. And nobody shopping for jewelry would confuse it with a music company. So trademarks are industry specific. That's why you'll often see the same trademark in two different places or very similar ones in two different places until a trademark gets famous, like Ford or Coca-Cola or something like that. Coca-Cola could object to you using Coca-Cola on jewelry or naming your law firm Coca-Cola, right? Because people associate, the company is so big and so famous, it's a famous mark, that you're not going to be able to do that. But when it's small startup world, you can often have multiple trademarks in different industries. Sometimes that's a good thing because you get the trademark you want. Sometimes it's a bad thing because other people are using it and you don't get that unique naming thing that you often want to have. So there are stronger marks and weaker marks, and strong marks are things you're familiar with. Amazon, Google, made up words. Acura, made up word, sounds like accurate, right? They were trying to portray the Acura as a better quality. I think it was Honda that made Acura, right? So they wanted to have a top end brand and they came up with the name Acura. Made up words make good trademarks because no one else is using them. Amazon and Google aren't made up, but what they have is the benefit of being very suggestive about the benefit. And we'll talk about that on the next slide. Then there's weaker trademarks, Napa, Cal, commonly used words. You can trademark them, but you're unlikely to build a lot of equity in them. Every now and again, you'll see, some brand name. But when you're dealing with smaller companies, to build brand equity costs a lot of money. So you're better off with a unique word you can spend your money on than a common word. How many things are labeled Napa or Cal? A lot of things. And so you're going to have a hard time rising above the noise level, which is always the difficulty in building brand equity. We're surrounded, like I said, thousands of trademarks, thousands of companies, and you need to rise above that. And finally, there's things that just will never be trademarks. Red car. And if you sell red cars, all you're doing is describing what you have. You're not going to get a trademark on it. My cookies. There's some guy out there with My Pillow or something like that. He has to spend a fortune to get the name brand recognition because there's nothing unique about it, right? Generic phrases, they don't go very far. They don't make very good trademarks. Couple of hints on naming. When clients come in, I believe that a good trademark is suggestive. It tells the buying public something about the quality or your product that they will remember. And when Amazon first started off, I thought Amazon was a dumb name for a bookstore, but their first slogan was the largest bookstore in the world. And the Amazon River, the largest river in the world by volume. So immediately I made a connection between Amazon bookstore online flowing at this endless flow of books in the Amazon River. Google is the same thing. Google, there's such a thing as a Google. It's spelled a little different. It's the number 1 followed by 100 zeros. So it's a big number. When Google first came out, it made its inroads into the tech world because techies knew what a Google was. They looked it up. And then it had a really fast search engine. And we used to sit around and put in search terms and watch how fast Google would do with the search. So they targeted kind of the geek side of the market. And that's where they were going with the really fast search engine. And they knew that the strongest thing they had going was a real fast search engine. So almost overnight, all of a sudden, people using Google, within a few months, everyone was using Google because that's what their techie guys told them to do. Emphasize the benefit, not the feature. I think lawyers might fall down on this if you don't have any sales experience. People buy the benefit of the product, not the feature of the product. So when you look at Google, the feature is the fast search. The benefit is you save time, and so that's what people are buying. And so when you look at naming a product, you probably want to look at what benefit does the customer get that you can deliver and try to create a trademark that emphasizes that. I know that we're in the legal profession, not in the product management profession, but if you're representing a client, they're going to come to you and they're going to ask about trademarks. And it's nice to say a little bit about what their business is and say, okay, how are you going to convey the benefit of your business to your customers with that trademark? Use syllables. Look at the word Acura. They took apart the word accurate, right? So syllables work. Foreign words that are well known, vino, amor, we can all think of foreign words that we use. They may be bits and pieces to go to a name that convey that idea. Creative spellings work. You see that a lot. I think the trend now is trademarks that instead of a word, they'll have a number. In fact, we just created a company with that the name of it was To Market, the number 2, and then Market. And of course, they're a marketing company. So the name of their company is To Market. So it seems to work pretty well. I think that was a pretty clever name. You will be asked probably to recommend to your client how to properly use a trademark. If you're going to enforce it, it has to be properly used. And a trademark should be used as an adjective describing a noun. So if you're going to have Amazon, that's the adjective, and online book sales, that's what originally, that was the product, that's the noun. So it was Amazon retail or Amazon book sales or Amazon, whatever their product or service was. You can't use the trademark as the noun that describes the product. In fact, Kleenex tissue had that problem. People started calling it a Kleenex. And once they started referring to a Kleenex, the trademark office ruled, I think it might have been a federal court, ruled that it's generic. Everybody calls it a Kleenex. It's no longer a trademark. So what Kleenex had to do was go out and start suing people to get them to stop calling it a Kleenex and refer to it as a Kleenex tissue. So Kleenex is the adjective, tissue is the noun. This is one of our clients. They do adaptive architectural lighting systems, as you can tell. The adjective, VODE, adaptive architectural lighting systems. Actually, we would call it VODE lighting, but this was the example I decided to show. So you see how the adjective describes the noun. The second thing you need to know if you're going to advise your clients, well, first of all, if you use the adjective, always put it with the noun so you don't get the Kleenex problem. The second thing you need to know is, should I use the little tm or the circle R? The answer is use the tm if you don't know. TM is the common law claim to a trademark. You can use it first, record the date, take a picture, a screenshot, whatever it is, record the date you first used the trademark, because under common law, the first to use has the rights. So you want to capture that. So if you have a client, they're talking trademark, tell them use the TM, send you a copy of however they're using it so you can look at it. Make sure it's used properly as adjective and noun thing I mentioned, and keep a record of the date it was done, because dates matter. The circle R means that you've registered the trademark. And what that means is that you've gone through the process that I described earlier, where you apply for a trademark registration, fight with the trademark examiner, they publish it for opposition, and eventually get the registration. Then you can use a circle R, and you'll be penalized if you use a circle R without going through the registration process. So just have them use the small TM when they initially start, keep a record of it, and make sure they're using it properly. The TM and the circle R tell the public this is your trademark. If it's a TM, you're making the claim. If it's a circle R, you've already registered your trademark. If you don't want to use those symbols, and often graphic artists don't like to do that because they think it interferes with the logo or the look and feel of whatever promotional material they're trying to make, you can just put a notice in the bottom example for our client, our maker VODE, and VODE logo or trademarks of VODE Lighting LLC in Sonoma, California. That is sufficient, but somewhere on that document, you want to put notice that this is a trademark, and that'll help you if you have to enforce those trademark rights later on, when you can say, yep, everywhere we printed it, somewhere on the document, and not hidden in the fine text in the bottom, but somewhere in the document is our claim to a trademark. So you should have known that this was trademarked. All right. I tell this story a little bit self-deprecating. When the law firm first started, we had the logo on the left, and it was very, very clever. We thought it was funny. There were only two people, Mr. Antero and myself. So it was A&T law firm and Antero and Tormey. And this looked really nice. Some client did it for us. So we said, well, we're going to use it. We like the colors and all that. It was also a huge mistake, because what we found out was the name of the law firm changed. It's now Antero, Tormey, and Petrin. And there's no way you can change that logo on the left to add a P to it. So we needed a different logo. And we realized then that we have to separate the logo from the text. The name of the law firm changes, the logo might change. You want to give your customers the flexibility to keep one or the other. If you fly a lot, some years ago, Continental Airlines merged with United Airlines. And what they did was they kept the Continental logo, but they kept the name United. So by merging the two companies together, when I walked into the airport, I saw the Continental logo and I recognized it as Continental Airlines, the airline I've been flying. And I also saw the United name. And United customers probably did the same thing. They came in and said, oh, this is United, you've changed your logo. Since the purpose of a trademark is to keep in your customer's mind your brand equity, your better advice to a client is to separate the image of your logo from the name in case either of them has to change. And logos change over time. We change styles. People like to see things a little bit different, so they might want to change the shape, maybe make the image in 3D image, change the color or whatever. So this gives you a lot more flexibility. A good clean logo, like the image on the right, straight lines, is easy to reproduce on a lot of products instead of having wavy, curvy lines. Also, it scales better. If I make it really, really small, it's still going to look like a triangle. If you look at the image on the left and I try to scale that, it's going to be difficult to understand that it's an A and a T and it's our company logo. So just a couple suggestions. And on to patents. The Constitution provides a legal authority for patents and actually copyrights as well. What can be patented? A process, machine, something you make, a composition of matter, the recipe for different types of steels, different types of metals, different types of plastics, oils, anything that's kind of mixed together can be patented as well. The important thing about patents is to understand what they do and what they don't do. They provide a defensive right, basically allowing you to stop somebody else from doing it. So if you have a patent on, I don't know, a chair with 4 legs, and somebody starts to bring that into the market, you can sue them for patent infringement, saying, no, I have a patent on a chair with 4 legs. What they don't give you is the right to make a chair with 4 legs. And let me give you an example. Let's say you have a patent on a chair that only has 3 legs. That means you can stop anybody from making a 3-legged chair. Well, if I make a 4-legged chair, it includes 3 legs. So your patent is included in mine. My patent is only an improvement on yours. So if my patent's an improvement on yours and I go to make it, you're going to say, hey, wait a minute, your 4-legged chair has 3 legs. That's my patent. It has at least 3 legs, may have more. That's the way we write the patents. Therefore, you can't make your chairs because it's an improvement on my existing patent. So a patent does not give you the right to make your invention. It gives you the right to stop someone else from making your invention. And that's probably the hardest concept for people to grasp about what patents do. So, and how they operate. The best patents are on core technology. So if your client has a relatively small improvement or a better way to do it, Facebook for kittens isn't going to cut it. Facebook's already been done. There's nothing new there other than you're changing the material. So what you're looking for is some core technology that is really valuable to them that they would want to keep, stop anyone else from using, basically. That's what the kind of the patent thinking is. Let's take a look at some details. A utility patent covers the usefulness of the invention. That's probably what you're familiar with. They last for 20 years. And the patent office, in typical government fashion, you pay 3 fees to keep it alive, thousands of dollars to keep it alive. Patents are expensive. To get a patent, your budget, $10,000 to $15,000 would probably be conservative. When you're done with the whole process, and then you're going to spend another $10,000 on the life of the patent, just taxes to keep it alive. There's a thing called a design patent, and they're good for 15 years, but they only cover the look of a product, what the ornamental design looks like. And there was a famous case recently, Apple v. Samsung, where Apple sued Samsung for the look of the phone, the iPhone. Samsung made a phone that looked alike, and Apple had fortunately patented the look of their phone and sued Samsung, and it was a $650 million judgment. So design patents can be valuable, but they're limited and they only cover the ornamental design. And at some point, the designs could vary enough where it's not infringing. So the court case looks like, Your Honor, these two look identical to the buying public, or Your Honor, they don't look identical to the buying public. That's the argument we make on those. Pretty much just take a look at them. And if you design a new plant, we don't do any work in that area, but you can get patents on a new design of a plant as long as it's not found in nature in the wild. Patents have to be novel. And one of the things I recommend people do is to do a quick patent search to make sure someone hasn't done it. Just because a product isn't on the market doesn't mean it's not patented. It just means it's not available on the market. So go to google.com patents and type it in and see if you can find it. There's a great website called Free Patents Online and lens.org. Both of them let you do quick patent searching, and you're probably better off having your client do the search before they contact someone like me, because it'll save them a ton of money if it's already been done. And the client might learn a lot more about the industry they're in and basically think of better ways to do it. I recommend now that when you do patent searches that you don't use all the same browser and all the same search engine. You do a little bit on one, a little bit on other, because I'm sure that they're collecting the search terms and trying to decide. I mean, it just seems an area ripe for espionage. I'm not saying they're doing it. I'm just saying it certainly seems very easy for them to find out what you might be patenting by looking at your internet searches. So you want to obfuscate those. And whatever results you find, keep a copy of them, because when you apply for a patent, you're obligated to tell the patent examiner what you found. You have to make that disclosure because it helps them do that examination process I mentioned earlier. In the United States, the patent goes to the first person to invent it. So we ask people, as soon as you have an idea, you can reduce it to tangible form. You don't have to build a prototype. You just have to tell me how you would make it and how you would use it. And we apply for a patent on that. And we often, our clients will go in and we will teach their engineers how to draft their own patent applications, and then we'll take a final review and file them. So when you have an invention, that's patentable, you have to file for a patent within 1 year of using it publicly. So if you're using it out in the public, or if you're just using it to make something going into the public, that's public use, you have to file within a year. But you want to file right away because someone else could file it first, right? If it's an invention, you run the risk that someone else will get there first. There's a thing called a provisional patent application, a provisional application that is less formal. And we do those, what we'll often do with the client is we'll have 3 or 4 inventions. We'll file 3 or 4 provisional patent applications, and then they only last for a year. So within a year, we go back and say, okay, how serious are you about these? Which ones should we pursue and which ones should we drop? But provisional applications, they're not formal, they're never examined. I'll talk about those on the next slide. And like I mentioned, you don't have to make a prototype. All you have to do is tell me how to make a prototype and how to use it. And that's sufficient for getting a patent. The provisional patent applications I mentioned earlier, it's a form of utility. You get to say I'm patent pending. They never get examined, but within a year, you have to file a regular utility application based on that. Patents are treated like real property. In fact, when you read the property laws, bought, sold, licensed, assigned, once you get patent pending, you can try to sell that patent. So you can file for a provisional patent application and then try to sell that patent. If you have a good demo working model, you might be able to have a better luck selling it. If you have a customer or a bunch of customers, that's really what you're looking for in the world of selling a patent, is some proof that your idea is really better and has market value. And remember, I think there's a little bullet on the bottom. They don't authorize you to make it, they just authorize you to stop someone else from making it. For your business clients, we like to say we want to create a culture of creativity. Identify patentable material. So have some process in the company to stimulate the engineers and designers to turn over to the company what would be good patentable material. And of course, if you can keep it a trade secret, do that. And ideally, you should apply for a patent before there's any public use. That's the safe way to do it. No one will know about it. Then when you put it out in public, you've already locked up your intellectual property rights, so you don't have to worry about it. If you read the patent literature, you'll find defensive and offensive patents, definitions of them. And some companies patent all kinds of things they never intend to make or use, or they buy patents and they just litigate over them. And some companies patent only their core technology. They don't want to be involved in a lot of lawsuits. And your job as an attorney is to kind of guide them through both of those processes, knowing a little bit more about patents now, hopefully, because of this lecture. Get a signed invention assignment, invention and copyright assignment from all your designers and engineers, especially those independent contractors. There's a case, the guy was a logo designer. He designed a logo for a company, but they had nothing in writing. And years later, he showed up and said, hey, I own the copyright on your logo. The judge said, if you can use your logo for your business, that's implied in the transaction, but for nothing else. So whatever logo the guy had, he wanted to put it on t-shirts and hats and all that. The judge said, sorry, you can't put your company logo on him because he owns the trademark. I didn't litigate this case. I heard about it from another attorney, but it fits the world that we think about. You want to have a signed writing transferring all of your rights in a copyright or an invention to your employer. so that you don't end up having litigation issues with your creative people later on down the road. Be clear who's an employee or a subcontractor, but I think it's always safe to just make them both sign the same assignment agreement that they're going to give you all the IP rights. And last, don't practice IP law unless you have it on your insurance. We have it on our insurance, of course, that's what we do. But the typical lawsuit is, well, if they had got a patent for me, I would have made $1 billion in profit. And that's why patent, intellectual property law insurance, malpractice insurance is very expensive. So just a heads up, before you take a dive into intellectual property law, you want to check it out with your insurance company first. The last slide, I'll hit the red on the bottom. I think when we promoted this presentation, I have a little book on intellectual property for startups. I'll be more than happy to send you a copy. There's my email address. If you email me with your mailing address, we'll get that in the mail to you. And I know I rushed through. We have about 6 or 7 minutes before the top of the hour, but I think, Ann, if you want to open it up for questions, I'd be more than happy to do that.
Pete, if you'd like to turn off your turn your slides off, we can bring everybody in.
Okay. I guess I have to stop sharing my screen, right?
You do.
I'm going to figure out how to do that. How do I?
But the top, stop share.
Oh, there it is. The big red button at the top, you mean?
Yeah, that one.
Yeah. No wonder I didn't see it. It's a big red button. How's that?
Okay, does anybody have any questions?
I ripped through a lot of stuff fast.
The first 10 people who registered, the first 10 or 20 people who in this case, 10 people who registered and actually attended will get a copy of the book. We'll figure out how to, Pete will get that to you. So
yeah, just send the addresses to me and we'll go ahead and get them in the mail. So.
Okay, no questions?
Well, that was easy. Usually I get flooded with questions, but I must have talked too fast. It's a big topic to pack into an hour.
Well, thank you, Pete, and thank you everyone for attending, and we will see you again sometime. All Section Mixer is June 9th. So we look forward to seeing everybody there. It's barristers are putting that on for us. And everybody take care. Thank you. Have a great day.
All right. Thank you.